Okay, we need to make sure we have taken care of all of our last minute housekeeping on the indictment, verdict forms, charges. Ms. Horsfield shared an email yesterday evening that has what we think are the last things we need to take a look at. So if we want to just walk through those. I guess maybe the verdict forms are the easiest thing to look at first. And y'all just let me know if those look okay.
You're looking at the email that says final doc?
Yes, final docs, charges, etc. from about 6 yesterday evening. And it attaches each verdict form, the redacted indictment, which we definitely need to still address some things on. And then the jury charges may change based on what we do with the indictment. So let's just look at the verdict forms first. And hopefully those are actually in final form.
This is minor, Your Honor, but do we need an entire page for the
Well,
overt acts, or is that just a
Here's
good way
the
to break
thing
it?
is I thought about doing some lines, but then I didn't want y'all saying, well, if you put 10 lines, that implies that they should find lots of acts. So I thought if we have a blank page, it is literally a blank slate, and they can put nothing, 173, it'll be up to them. So that was my thinking.
Well, I certainly prefer that to the lines. So,
Okay.
but it's
All
very
right.
difficult to please us.
All right, then that's why it's there.
Well, Your Honor, as you know, the state would prefer the lines, but given that you made it clear, you sort of made your mind up on this issue, I think that this is the most appropriate middle ground. The way it was before implied that there would be very few or any. And this is, as you said, it's a blank space.
Okay. All right. So any other items? All right.
And I don't know if it's the same thing Mr. Sharp's saying, but on Mr. Stillwell's verdict form.
Yep.
For count 49 and count 52, just for consistency, I would put the not guilty first and then the guilty.
I agree. Don't know how that one happened. Ms. Persfield, can you switch those around? Thank you for that catch.
Your Honor, I'm going to object on count 2 and count 49.
Yes.
I don't think we should be putting the victims' names.
Why?
Well,
I mean, if you're going to object, you need to give me a reason.
because, I mean, I think it's clear what the 2 counts are. If we put a date on it, I wouldn't necessarily have a problem with it. I mean, I think it's clear that my client's charged with 2 murders. I don't think it's necessary to put the victims' names next to each count.
All right. Well, I appreciate that objection. I overrule it. All right. Anything else on Mr. Stillwell's verdict form? All right, hearing nothing, we will move on to Mr. Kendrick's verdict form. And it's possible that then, I don't know if we have a guilty, not guilty reversal on that one, but if
No,
we do, we'll
it's correct on that one.
Okay.
Or consistent. Let's use that
consistent.
word,
Okay.
consistent, Your Honor.
All right, anybody have any issues then on that verdict form? I guess maybe you could on the, I don't know why it's not showing up on mine. I don't have lines under this blank day of blank, but it looks like you do on yours, Ms. Persfield. So as long as they're there. Okay. All right. So looks like at least the verdict forms are in their final form. the redacted indictment. And as y'all can see, and from the email, I determined that Overt Act number 175 shouldn't be in there because it seems to not assert one of the necessary elements to have made that a crime.
Yes, Your Honor. I understand the thinking behind it, but I don't think that's consistent with Georgia law. I think we've already established and the court has recognized an overt act doesn't have to be a crime. And therefore, we would not have to have all the elements present.
You are asserting the crime of, did commit the felony offense of whatever, OCGA section whatever, so.
That was the first part. Second.
Okay.
Second part is this. Under Georgia law, and federal law is consistent as well, the state does not have to allege all of the elements of an overt act that does happen to be a crime because it is not separately charged. The pleading rules are not the same. You can't generally demur to an overt act. And so it's, while it might not be adequate as a freestanding charge, an overt act telling the jury what we are saying was done, that would still be sufficient. They don't have to decide it's a crime. They just have to decide it's an act in furtherance of the conspiracy, because they're not separately convicted.
I don't agree. If you have law that is on point, show it to me. But if you are asserting he committed the felony offense of possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm, and you cite 1611-133, one of the essential elements of that is that he's possessing it while he's committing a crime. And y'all don't assert that.
I understand, Your Honor. As far as it not needing to be a crime, Yates versus United States, 354 U.S. 298.
That says if you assert it as a crime inside a statute, it still doesn't have to be a crime? I know an overt act doesn't have to be a crime. Are you saying that Yates is going to tell me that if you assert he committed X crime, you don't have to actually be asserting a crime, even though you're saying pursuant to XYZ statute?
So I'm citing Yates for the initial principle.
That I understand.
Okay. I'm not representing to the court that Yates says all of the additional things you said. I don't have a cite off the top of my head, so I'll simply have to represent this to the court. But I will tell you that is well-established federal case law, for example, that if a defendant is charged, let's say count one is conspiracy, and there is an alleged overt act, that overt act is also alleged as count two, independently.
Right.
The defendant can be acquitted of count two because the jury finds an element of that separate charge was not found, but it still functions as an overt act in furtherance of the conspiracy. Especially when, like the ones we're talking about here, there's more than one actor involved.
There's not here for 175. There's only Mr. Nichols.
Okay, all right. I still don't.
All right. Again, if you find some law that is on point, you let me know.
All right.
By that reasoning,
I'm. If you find some law, we'll deal with it further. Otherwise, let's move
I
on.
agree, I'm with the court,
Okay.
but I'm wondering if that should also not apply to 174, 189, and 190.
So on those, I would like to know. Let's see. Good question. All right, 174 and which others?
189, oh, sorry, go ahead.
189 and 190.
think those present the same situation. Yeah, I think you're correct. So looking at, like, for instance, on Mr. Stillwell's March 17th, possession of a firearm allegation, it's also a substantive count 64, and it's saying that he did that on March 17th, and we know from the evidence that what everybody is talking about is the gun that was, I don't know if it was thrown out of the car, but the gun that was discarded during the chase. And, you know, I mean, I think we were looking at sort of the somewhat odd language of 1611-133.
Right. So I guess my stance, Your Honor, is that ultimately, when it comes down to it, the state did not indict this correctly, and the state did not put it in the overt acts correctly, and they specifically alleged a crime, a specific crime in the overt acts. So we moved for a directed verdict on the substantive charges, and Mr. Abate and the state provided case law that saved that and opened up the possibility for a lesser included, and I get that, but I don't see that same mechanism of saving the charge for overt acts.
Right.
And so that's kind of where we're at. Essentially, I'm suggesting that there should be a directed verdict on the overt acts.
Yeah, I mean, I think those overt acts need to be removed. 174, 175, 189, and 190.
Your Honor, may the state briefly address that issue?
Sure.
The state does believe that for the reasons that Mr. Floyd was just articulating about the case law for a substantive count of 133, as the court, as we have addressed, you can have the possession of firearm by convicted felon because it's a lesser included. Legally speaking, the argument for, an overt act language, which does not have to have as much specificity as a count that the jury is deliberating on. The first language in 190, for example, is possession of firearm by convicted felon. It obviously has the superfluous language because it's not completed of the underlying felony, but that same logic for a count, which has to be more perfected than overt acts do, because overt acts do not have to be crimes.
I understand they don't have to be crimes,
Yes,
but
Your
they've been alleged to be crimes with specific statute numbers. And yet y'all haven't included what would be essential to make them a crime. So are you arguing that the overt acts should be lesser included also, or what are you saying? What's your argument?
Your Honor, my argument is that if the jury is tasked to decide if on March 17, 2022, when Shannon Stillwell possessed the firearm by a convicted felon in furtherance
Previously convicted of a felony involving use or possession of a firearm.
Yes, Your Honor. In the state's mind, the lesser included argument on a substantive count is a harder standard to meet than an overt act. There's no such thing as like a directed verdict on an overt act as there is with substantive counts. And so the state believes that same legal principle of why lesser included of possession of firearm by convicted felon can be included on a substantive count is even stronger on an overt act.
So are you, so I'm
Yes, Your
clear,
Honor.
are you asking that these be converted into just possession of a firearm by a convicted felon in the overt acts? That's
Essentially,
kind of a lesser included crime?
yes, Your Honor. And if the state, or if you, like, for example, if the state, from my understanding, were just to, redact, or essentially, yes, Your Honor.
All right.
And I'll let Mr. Floyd.
I mean, I think that there is evidence presented for that. And I hope you'll understand what my thinking is on because 133 requires that it be asserted that they did this while they were attempting or committing a series of crimes listed or types of crimes listed in the statute, and that is in nowhere listed in your overt act. That seems to be problematic. But simple, if you will, possession of a firearm by a convicted felon, you don't have to be possessing it while committing a crime, you just have to be possessing it. And that has been asserted in each of these overt acts.
Well, and Your Honor, just to supplement what my colleague, Mr. Adkins, was saying, I'm holding this up because I've been informed they can't hear me behind otherwise. The point that this does different work as an overt act than it would as a separate substantive charge. Frankly, only just the fact that he had the gun during the course of the conspiracy is enough for it to be an overt act. And just he is in possession of a weapon.
I know
The
y'all
rest of the
didn't
details.
allege it that way.
Well, that may be so, but it still does the work under it. I mean, it wouldn't.
They cannot return. I find overt act 190. He committed this crime when you have not asserted that every element of that crime. They can't possibly find that when it hasn't been correctly asserted. Y'all have left out an element. So I'm, unless you got case law, you're not going to convince me on that one. We have moved on to whether it should be redacted, modified to essentially assert a section 131 crime of simple possession of a firearm by a convicted felon. And I think that has been sufficiently asserted in each of these overt acts.
Excuse me, and the state
Yes.
may be able to find a case, but I haven't, I mean, and you may be aware of a case, Your Honor. And in my limited time, I haven't found one, but I don't believe that there's a case that permits the court to go back.
I do
and
not have
fix-
any idea whether there is.
Yeah, I do not believe that you can go back now and fix the error that they have made or whatever, fix what they have done at this point in time by modifying the allegation
Yeah.
of this overt act. At this point, I just don't think you can do that. I think
I
the
don't
only
know.
option is to redact it, Your Honor, and it would be, I think it would be error to go ahead and change that.
I don't know. So
Because that's what we have been,
I'm sure we'll have some time between now and when we actually send it out for somebody to do some research on that. So we'll put a pin in overt acts 174, 175, 189, and 190. They're absolutely not going to be included as a 133 offense. Y'all can let me know if there is case law out there that answers our question on the floor right now of whether they could be converted into a 131 offense, since it at least asserts that, but I don't know whether we can change it like that. So we'll come back to that.
Just so it's clear, do you want specific law subject and apart from what was provided last week that would allow?
Yeah, because we need it specific to, can an overt act, in the midst of a trial after the evidence has been closed, be modified to assert what would be a lesser included crime that is fully alleged in that overt act. All right. So our next issue let me jot myself a note down. All right, the overt acts that include Mr. Kendrick and others that I granted a directed verdict as to Mr. Kendrick that basically with regard to the possession of cocaine and possession of codeine. And that's easy enough to redact out of the substantive count of the indictment itself, although we need to actually look at, if y'all can open up the, what count is that, Ms. Persfield? Okay.
you mean
I'm
the-
sorry, the count. We'll do the substantive count first. I think it's highlighted. Okay. If y'all will look at count 57, the issue, I would just strike possession of codeine with intent to distribute and possession of cocaine out of the indictment. I know that it doesn't really matter with regard to Arnold and Williams. I mean, they're on this indictment, but they're not deliberating about them. So it really doesn't matter, I don't think, whether something that those people could be charged with is included or not, because all that the jury is deciding is Mr. Kendrick. So is everybody okay with us just redacting out possession of codeine with intent to distribute and possession of cocaine on the substantive count?
I'm okay with that, Your Honor.
Okay, all right. Now, the somewhat more complicated issue is when we go back to the overt acts, because that same thing is essentially included as an overt act as well. And those start around overt act 183.
And on that, if I may just briefly speak to that, Your Honor. I mean, we have a similar situation, I guess, that we're fighting with those others, and that the question is, do you redact the entire count, right?
And I think not, because with an overt act, it doesn't have to be that Mr. Kendrick was the one that the jury determines whether or not committed. The other people, they could
but
think,
here's-
well, Mr. Williams possessed that codeine, so.
But here's the problem with that. Let's say they come back in the jury verdict form and they list 183 as one of the overt acts that they find, right? We don't know if they found that
Right.
because they found that Mr. Kendrick.
Agreed. So
So
here's
your-
here's a possibility.
All right.
So I'm going to throw this out here and y'all can let me know what you think. If we have a 183 that alleges that the three people that are included, Arnold, Kendrick, and Williams, possessed marijuana with intent to distribute and a firearm during the commission of a felony, because those are still live with regard to Mr. Kendrick. And then maybe a 183A that says, you know, or posits that Arnold and Williams possessed the codeine and the cocaine. And then we know, okay, it's 183. They think they all, or somebody at least, possess those two things. Or we think maybe Mr. Williams or maybe Mr. Arnold possessed the codeine or the cocaine, but we know it can't have been Mr. Kendrick because I've already determined that.
So is the, just want to make sure I understand the court's suggestion. There'd be essentially I'm going to do a slightly different numbering system. There'd be a 183A, which has all three individuals listed, but you would remove the codeine and the cocaine. And then there would be a 183B, which would just
Sure.
be Arnold and Williams with the.
Codeine and the cocaine. Yes, that's what I'm proposing.
My only question with that is, are we facing the same situation, or with a question of, can we then go and modify? I guess we can modify these overt acts. I don't know
mean,
if we
it
can
seems
modify.
like that's an easier question because it's based on me having directed a verdict that Mr. Kendrick can't have done those two things, so it inures to his benefit.
I'm willing to go with your suggestion as long as it's not taken by the court or anyone else, that I'm conceding that the ability to modify this overt act for A and B due to a directed verdict is a concession that you can modify those other overt acts that we referred to earlier.
Understood. And if we find out that you in no way can modify, then I guess our solution would be to just strike those two things entirely. But I don't think that is actually fair to the state when it could be that, you know, they asserted that all three of them did that, and it could be that the jury thinks one of them did that.
Yeah, and I'm not, while I probably should, I'm not disagreeing with the court on what you're saying
Yeah.
with respect to that. The real key is going to be if we can find any law and what that law says.
Sure.
That'll be determinative
All right.
of some of
And
those issues.
you say I probably should, but you shouldn't if you, I mean,
Well,
I appreciate that you take your duty of candor seriously. I really do.
Thank
So
you.
thank you. Yes, sir.
Your Honor.
With regard to count or Act 183,
Yeah.
if the jury unanimously finds that this overt act was in furtherance of the conspiracy,
Yeah.
I believe with the instructions the court will be giving, when you have multiple parties, you know, and could mean, you know, and can be or in pleadings. And so if the jury finds that this, which includes Mr. Arnold, Mr. Williams, and Mr. Kendrick, if they find it's an act in furtherance of the conspiracy, it would be attributable against Kendrick and Stillwell. So I believe the state current belief is that the way it is worded is safe. The instructions the court will be given about possession, constructed, actual, how you read and in indictments or pleadings, so that the jury, who's presumed to follow the court's instructions, will use those legal principles. And if they do find this overt act in furtherance, it will be following that law.
Here's the
Yes, Your
challenge with that, and just kind of think through this hypothetical with me. We have got overt act 183 that says Arnold, Kendrick, and Williams. Let's assume that The only overt act the jury comes back with is 183. And all we know is they found 183. But how do we know then that they didn't say, you know what, I think Mr. Kendrick possessed codeine with intent to distribute. That is all I think, and that is why I'm finding this count. When I have already directed a verdict against the state and on the side of Mr. Kendrick with regard to that, that seems problematic. And then the whole case gets reversed, assuming that that's what happens.
Understood,
And
Your Honor.
I doubt if that's going to come to fruition, but legally speaking, that's my worry with leaving it the way it is.
Understood, Your Honor. I'm thinking through it with the court
Yeah.
right now.
Okay.
So if we could come back to this.
All right.
Thank you, Your Honor.
I guess what doesn't make sense is we didn't have to charge the separate offenses. We could have just put those offenses like we did in the overt act, and your directed verdict on those obviously would have had no.
That's true.
There's no directed verdict.
That's true, but I'm worried about an inconsistent verdict, which is not allowed.
Well, inconsistent verdicts in Georgia are allowed. Georgia doesn't have inconsistent verdicts in what they don't know.
Well, what is it that we phrase that it's not inconsistent? What is it called? Repugnant. And I don't know, this would qualify as that, but it's factually, I don't know the answer.
Your Honor,
I just know the question.
I think we'll have time to return to this.
Okay.
I'd like to bring you, bring you some authority. But
Okay.
I can tell you that my understanding under analogous federal law is that there is not such a thing as an inconsistent verdict as between the substantive count on a charge and that being an overt act. The jury could find it to be the overt act, even though the substantive count they rejected explicitly.
Okay, but that's not them, all right. If you can, I think that would be an inconsistent verdict, which wouldn't be problematic. Our situation is not that. Let's assume that nobody else is charged, that it's just Mr. Kendrick who is alleged to have done overt act 183. And I have directed, and it's only, codeine. And I've directed a verdict on that count with regard to the substantive count. Could we then leave that overt act in? When I've said as a matter of law?
Actually, I believe the answer.
So that's our question.
Right, understood. It helps to frame the question.
Okay,
And we're gonna come back and talk about it, so I don't want to.
all right.
I'd like to be.
Think
better
it through
informed.
before we know what the case law is.
Better use of my time.
Okay,
Thank you.
appreciate it. All right, the next thing is on the overt acts that allege possession of a firearm by a convicted felon that aren't also substantive counts. We were adding definitions of, like, if, I don't know, Mr. Arnold was alleged to have committed an overt act of possession of a firearm by a convicted felon while he was convicted of, I don't know, dealing in some kind of drugs. And we would need to have defined what is that underlying crime in our overt acts definitions. But that would only be true, I think, if we then had, well, let's not have it be Mr. Arnold. I'm talking about Mr. Kendrick and Mr. Stillwell. They've been alleged to have been convicted felons based on convictions for gang act and burglary with regard to Mr. Stillwell, shoplifting and possession of dangerous drugs out of Arizona, as to Mr. Kendrick. I just want to make sure that those convictions are in evidence. And that ought to be easy enough to check. And honestly, I think Ms. Hilton, you maybe even cited what the exhibit numbers were. I just want to make sure that is what those matched up to.
Yes, Your Honor.
So I think it was, what you said was 60G, 30Q, and 487VV. So can we just pull those and, or if you've got it on this, you had it as a slide, actually. If you want to just pull that up too, and let's look.
And there are other convictions for Mr. Stillwell that were admitted as well.
Right, but I'm just, at this point, trying to figure out which crimes not otherwise defined do I need to define for purposes of overt acts? And we have not yet defined shoplifting, burglary, or whatever that Arizona dangerous drugs thing is, and I'm not even sure how to define that one, but looking at the indictment, plea, and sentence would help. And are we sure that was a felony shoplifting? Because shoplifting isn't always a felony. So can we just pull those convictions?
You want me to pull what I posted in the,
I mean, the actual
you want me to pull
piece of
that?
evidence would be probably the easiest. Thanks.
Make sure you get it back. I don't think I don't know how many kids he has. I don't think there's anything too good.
Yeah, I won't be on it. So I need to see what.
Did y'all find the evidence?
Yes, Sean.
Can I look at it?
You were talking, that's why I'm sorry, I waited.
We were just dealing with other issues.
And Your Honor, unless I missed it, I don't believe the Arizona conviction came into evidence.
This is the only. If 438 VV, now you had cited in your closing presentation 487 VV.
It was 438 BB, which is this.
Okay,
For.
all right. So it doesn't look like the Arizona conviction came in, so. All right, so we're starting with overt act number 3, y'all allege that Mr. Stillwell possessed marijuana with intent to distribute on 8/23/13. Is there a conviction for that? In which one is that?
That is going to. Yes.
Hmm?
One moment.
It's neither of these.
I'm looking at the other one here.
Aren't there three for Mr. Stillwell?
Yes, Your Honor.
All right, you handed me two.
I handed you the two that we discussed.
Okay, can you hand me all of the convictions for each of them that are in evidence? I just assumed that you had cited all of them in your closing, but that's okay. It's probably this one. No, this is a Tennessee. It can't be that one. Can't be that one either. All right, I think it's still somewhere in one of those bins, if it is in evidence. All right, Ms. Pressfield, the burglary one, there is a conviction for, so we do need to define burglary in our overt acts.
Your Honor, for the 2013 Act 3, we put up evidence of that. I'm trying to see
2013 Act.
Act 3.
Okay,
Sergeant E. testified.
okay, all right, as long as there's, okay, so there's some evidence, okay,
Yes, Your Honor.
all right. Just a second, sorry. All right, and we've already defined possession of marijuana and to distribute anyway. Yes.
I don't think it's necessary to define the, I guess, the burglary for the example that you just referenced as it relates to that conviction. They just need to determine that what they have is a felony conviction and that they've been convicted of that felony. There's no added, I think we're just adding extra charges
Okay.
and confusion to the jury to have.
I see what you mean. That's a good point. If there's a conviction in there, then they don't need to make a determination whether that occurred. It's proven by the conviction. All right, that's reasonable. All right, so then 55. So are there other overt acts that have been proven by somebody else's conviction being admitted such that we wouldn't have to define those either? right, y'all, Overt Act 58 alleges possession of a firearm by a convicted felon by Mr. Kendrick by possession of a firearm having been convicted of that Arizona felony. Is that conviction of possession of a firearm in evidence? Not the Arizona conviction, but I guess, I don't know if it's I assume Georgia conviction for possession of a firearm by a convicted felon?
That's the one that you have for 38
Okay.
That October 1st, the conviction for that October 1st crime is 438.
All right. All right, so. All right, I'm gonna give y'all back all of this evidence so you can put it back where it goes. And then y'all come up with any other overt acts where we won't need to define a crime because it's established by some alleged co-conspirator's conviction that's in evidence.
Your Honor, we are looking. Your Honor, we're looking at that now, and I think the court just addressed this, but just with the Arizona conviction,
Yeah, we don't need that one. We just need that one's satisfied.
thank you, Your
Thanks.
Honor.
$53. Sorry, overt act 34 is Walter Murphy, possession of firearm. Do we have, is that established by a conviction? Or am I going to need to define robbery?
It's established by conviction, so you would need to define robbery.
Okay, that may have been the only reason we were defining robbery. So we would not need to if there's a conviction in for him. So we can take that out of our jury charge. I'm glad you pointed that out, Mr. Abadi. That'll make it somewhat easier. Mhm. Oh. Right, I'll have to look in a second. Okay, it doesn't look like there are any other overt acts because I just did a global search in the indictment for the term convicted felon, and that looks like those were all of them that didn't otherwise have some definition anyway.
What's the name of the case you found this out from 132 to 130? Wow, Martinez is one of them. Martinez, do you remember the site for that? I did. Thank you.
All right, y'all continue to research. I need to go up to my chambers and see if some changes might be saved on my computer up there if it aren't saved in a document down here. All right. Yeah. Okay.
Your Honor, we've located some authority on main cases, United States versus Elliott 571, F second 880, it's a former Fifth Circuit case. Elliott dealt specifically with the question where the defendant argued that acquittal on a RICO substantive required acquittal on a RICO conspiracy.
Mm.
And the court said no, it did not.
Yeah, that's not.
It's an often, it draws the distinction, but that being said, we are looking at the changes that were just forwarded to us.
Okay.
And think that there, for the vast majority of these, there may be a pretty simple, direct workaround that addresses the issues.
Okay. I'm not sure we need to decide it before the jury charges anyway, so. All right. Anything else then? Otherwise, I'm gonna have the jury out and go ahead and charge them. All right, let's get the jury out. violation of the Georgia Controlled Substances Act, 61, possession of a firearm during the commission of a felony, and 63, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. Mr. Stillwell has been indicted for counts 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, 2 and 49 are counts of murder, 50, participation in criminal street gang activity pursuant to subsection 1 of that statute, 51, participation in criminal street gang activity pursuant to subsection B of that statute, 2 counts of possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm in counts. Those are counts 52 and 64. And then count 54, which is possession of a firearm during the commission of a felony. You will have a copy of the indictment with the relevant charges with you during deliberation. Each defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The instructions that I give you will apply to each defendant individually. So when I say the defendant or a defendant, the instruction applies equally and separately to each defendant. Further, your determination of the issues set forth in the verdict forms must be made as to each count and as to each defendant individually. A defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a reasonable doubt is the doubt of a fair-minded and impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt. It's a doubt for which a reason can be given, arising from the consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If after considering the evidence, you believe beyond a reasonable doubt that a defendant is guilty of an offense alleged in the indictment, you would be authorized to convict the defendant of that offense. If the state fails to prove the defendant's guilt of an offense beyond a reasonable doubt, it would be your duty to acquit the defendant of that offense. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes the testimony of the witnesses, the exhibits admitted during the trial, and any stipulations of the attorneys, which are facts to which the attorneys have agreed. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into stipulations about certain facts, and these 4 stipulations are marked as joint exhibits. Where parties stipulate facts, that is in the nature of evidence, you must take that fact or those facts as given without the necessity of any further proof. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. Direct evidence is is that which can be seen or heard or otherwise directly sensed. It may be brought into court in the form of exhibits or the testimony of a person who asserts that he or she has actual knowledge of a fact by personally observing or otherwise witnessing that fact. It is evidence that points immediately to the issue in question. When direct evidence points by inference to an obvious, likely, or reasonable conclusion, even though that conclusion is not directly observed or otherwise sensed, that's said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that tends to prove or disprove another fact by inference, that is, with consistency with such a fact or elimination of other facts, or that only tends to establish a conclusion in question by its consistency with such conclusion or its elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence alone, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or a greater degree of certainty on the part of you, the jury, to return a verdict based on circumstantial evidence than upon direct evidence. There's no rule that either circumstantial or direct evidence is stronger than the other is conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. And whether it's dependent upon direct or circumstantial evidence or both, the true test is whether there's sufficient evidence, whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. You, the jury, must determine the credibility of the witnesses. In deciding credibility, you may consider all of the facts and the circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or their lack of interest in the case and the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are witnesses who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility, and this may include evidence of a character for untruthfulness, bias toward a party, or felony criminal convictions. In determining the credibility of any witness whose credibility has been attacked or challenged, as I've described above, and any testimony given by him or her in court, you may consider, where it's applicable, evidence offered to support the credibility or believability of such a witness. The credibility of a witness may also be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony that the same witness gave before the trial started. It's for you to decide whether there's a reasonable explanation for any inconsistency in a witness's pretrial statements or testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. In assessing the credibility of a witness, you may consider any possible motive in testifying if that is shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of all of the witnesses. The testimony of a single witness, if believed, is generally sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. An exception to this rule is made where the witness is an accomplice. The testimony of an accomplice on its own is not sufficient to warrant a conviction. An accomplice's testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the inference of the guilt of the accused, independent of the testimony of the accomplice. It's not required that supporting evidence be sufficient to warrant a conviction, or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act, and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all of the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The testimony of one accomplice may be supported by the testimony of another accomplice. Whether or not the testimony of one accomplice does in fact support the testimony of another accomplice is a matter for you to decide. The sufficiency of supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is also a question for you to determine from the evidence in this case. Any out-of-court statements made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only against the particular defendant who made it. A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, a defendant does not have to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose or against some parties and not others, or for some counts and not others. I have previously instructed you as to how to consider particular evidence that was limited over the course of this trial. Such evidence may be considered by you only for the sole issue or purpose, or against only the party, or only for the counts for which that evidence was limited, and not for any other purpose or against any other defendant or for any other counts. You received evidence of certain prior convictions of these defendants as well as certain other witnesses in this case. You may consider the conviction of Mr. Kendrick only against Mr. Kendrick and only as to count 1 and as to the required element of being a convicted felon in count 63. You may consider the convictions of Mr. Stillwell only against Mr. Stillwell and only as to count 1 and as to the required element of being a convicted felon in count 52 and 64. You may consider the convictions of any witnesses only insofar as they may relate to attacking the credibility of that witness and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. In addition, some but not all of the factors you may consider in assessing the reliability of any identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have had, whether the witness on any prior occasion did not identify that person as the alleged perpetrator, and the length of time between the crime and the out-of-court or any out-of-court identification. It's for you to say whether under the evidence in this case, the testimony of the witnesses, and the facts and circumstances of the case sufficiently identify someone beyond a reasonable doubt as the alleged perpetrator or a party to an act. It is not necessary that the defendant show that another person committed the alleged act. The burden of proof never shifts to the defense. Defendants are charged with crimes against the laws of this state. A crime occurs when a law is violated by a defendant's intentional action. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe it existed from the facts proven before you. It may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a criminal statute, but it simply means the intention to commit the act that is prohibited by the statute. A defendant will not be presumed to have acted with criminal intent, but you may find such an intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. Whether or not you make any inference or inferences such as that is a matter solely within your discretion as the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. A party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crime of murder, that's counts 2 and 49, possession of marijuana with intent to distribute, count 58, or possession of a firearm, counts 52, 54, 61, 63, and 64, was being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt in order for you to convict on those counts. If you find from the evidence in this case that the defendant had no knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts that I just referenced was being committed, or that the defendant did not knowingly and intentionally commit, participate in, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant of that count. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts I just mentioned was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant of that count. You are not authorized to find a person who is merely present at the scene of the commission of the crime at the time it was committed guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in its actual perpetration of the crime, or participated in the criminal endeavor. You are not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of a crime, unless the evidence shows beyond a reasonable doubt that the person helped in the actual perpetration of the crime or participated in the criminal endeavor. Next, I'm going to define for you the elements of the crimes that are alleged as counts against either defendant. Then I will define the meaning of any crimes that are alleged as an overt act, but that I have not yet defined. When a count of an indictment charges that a defendant committed a crime in more than one way, the state does not need to prove that the defendant committed the crime in every one of the ways alleged. The state may prove that the defendant committed the crime in any one of the ways charged. If the evidence shows that the crime was committed by the defendant in any one of the ways charged, you would be authorized to convict him of that count. And RICO is one of the counts that is charged as having been committed in more than one way. In order to convict, the state must prove that the crime was committed by the defendant in at least one of the ways charged. For conspiracy to violate subsection A of the Racketeer Influence and Corrupt Organizations Act, which I'm going to refer to from now on as the RICO Act, the state must prove that the defendant knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the co-conspirators committed an overt act after May 10th of 2017 to further a criminal objective of the conspiracy. For a conspiracy to violate subsection B of the RICO Act, the state must prove that defendant, while associated with an enterprise, knowingly and willfully conspired with one or more others to participate in the enterprise through a pattern of racketeering activity, and that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. Conspiracy means an agreement between at least two people to commit an unlawful act. The agreement may be express, that is, stated or written, or it may be tacit, that is, a mutual but unspoken understanding to accomplish a or to pursue a common criminal objective. The existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators before and after any alleged offense, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. The state does not need to prove that each conspirator agreed with every other conspirator, knew all of his fellow conspirators, was well aware of all of the details of the conspiracy, or contemplated participating in the same interrelated crimes as every other conspirator. Whether a conspiracy existed is a matter for you to determine. Overt act means an outward act made in furtherance of a conspiracy. The overt act may, but does not have to be, a crime in and of itself. Some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are when you have the indictment back with you, because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that are not already defined when I'm defining the substantive counts. Enterprise means a group of individuals who are associated in fact, whether or not all of the members know each other. To be an enterprise under the RICO Act, the group must have a common purpose, an ongoing nature sufficient to pursue its purpose or purposes, and at least a loose or informal relationship amongst those involved. The group does not need any form or structure beyond what is necessary to conduct a pattern of racketeering activity. The group may be associated together for both legal and illegal purposes. In determining whether an enterprise existed, you may consider any evidence of a pattern of racketeering activity. When people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be an act of all of the conspirators. However, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise. If you find that the defendant did not knowingly and willfully join a conspiracy as described above, then you cannot contribute the statements or acts of another person to the defendant. Racketeering activity means committing or attempting to commit any of these crimes: murder, attempted murder, aggravated assault, aggravated battery, theft by receiving stolen property, armed robbery, terroristic threats, use of an item with an altered identification mark, possession of a firearm during the commission of a felony, possession of a machine gun, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, possession of a weapon by an inmate, possession of a cell phone by an inmate, possession of cocaine with intent to distribute, possession of hydrocodone with intent to distribute, possession of marijuana with intent to distribute, possession of MDMA with intent to distribute, possession of methamphetamine with intent to distribute, possession of cocaine, or possession of oxycodone. I will define these crimes for you shortly. Racketeering activity also means any act or threat that involves murder, robbery, theft by receiving stolen property, or dealing in narcotic or dangerous drugs. A pattern of racketeering activity means engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of one or more interrelated incidents, schemes, or transactions. Interrelated here means acts that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and that are not isolated incidents. The criminal objectives of the conspiracy alleged here are preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, obtaining money, weapons, or other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs, and obstructing law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. A person commits the offense of violation of the Georgia Street Gang Terrorism Prevention Act, which I'm going to refer to from now on as the Gang Act, when that person, while associated with a criminal street gang, commits a crime that constitutes criminal gang activity. To prove a violation of subsection A of the Gang Act, as alleged in counts 50 and 57, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus, that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang. To prove a violation of subsection B of the Gang Act, as alleged in count 51, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity in order to maintain or increase his status or position in the gang, and again, a nexus or a connection between the crime charge and the gang. That is, that the crime was committed to further the interests of the gang. Criminal street gang means any group of 3 or more persons associated together which engages in criminal gang activity. The existence of criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Criminal gang activity means the commission, attempted commission, conspiracy to commit any criminal offense that involves violence, possession of marijuana with intent to distribute, possession of a weapon, or use of a weapon. For purposes of count 50, 51, and 57, which are the gang counts, murder, possession of marijuana with intent to distribute, and possession of a firearm during the commission of a felony constitute criminal gang activity. For malice murder, the state must prove that a defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to show premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state may, but does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For possession of a firearm during the commission of a felony, the state must prove that a defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is one of the following: a crime against or involving another person, or a crime involving possession of marijuana with intent to distribute. Murder and possession of marijuana with intent to distribute are felonies, and for purposes of this offense, a firearm includes a handgun. The indictment charges each defendant with possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. I am not going to charge you on that crime because the state concedes that the description of the crime in the relevant counts of the indictment left out an element of either the defendant having previously been convicted of a felony, or of the defendant having previously been convicted of a felony involving the use or of possession of a firearm. That should be or. So you will be considering only the lesser included offense of possession of a firearm by a convicted felon to get to those counts. And for possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. Possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. And again, for purposes of this offense as well, a firearm includes any handgun. For possession with intent to distribute marijuana, the state must prove that the defendant possessed any amount of marijuana with intent to distribute. Intent to distribute means intent to unlawfully deliver or sell. Marijuana means all parts of the plant of the genus cannabis, whether growing or not, the seeds, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds, or its resin. Marijuana does not include the completely defoliated mature stalks of such plant, fiber produced from such stalks, oil or cake, or the completely sterilized samples of seeds of the plant which are incapable of germination. And it does not include hemp or hemp products, and it does not include samples of tetrahydrocannabinols or THC. The state must prove that the defendant possessed the marijuana and or the firearm at issue in this case. Possession may be either actual or constructive. It also may be either sole or joint. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the marijuana or over the firearm, depending on which count you're considering. Constructive possession means that at the time of the alleged offense, the defendant did not have direct physical control over the marijuana or the firearm, but did knowingly have both the ability and the intention to exercise control over the marijuana or the firearm. Sole possession means that only the defendant had possession of the marijuana or the firearm. Joint possession means that the defendant shared possession of the marijuana or the firearm with at least one other person. If you find that someone other than the defendant had an equal opportunity to possess the marijuana or the firearm, you would be authorized to convict the defendant only if the state proves that the defendant knowingly possessed the marijuana or the firearm. And I'm now going to define for you any alleged crimes that are alleged in the overt acts that I have not already defined in the substantive counts. So the following definitions apply only to certain acts that are alleged in count 1 of the indictment as overt acts. Aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the alleged perpetrator assaulted another person with a deadly weapon. Assault means to commit or to attempt to commit a violent injury on the person of another. And to prove assault, the state doesn't have to prove the other person was actually injured. However, the state must prove that the alleged perpetrator attempted to cause a violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Aggravated battery. For this crime, the state must prove that, for aggravated battery, the state must prove that the alleged perpetrator maliciously caused bodily harm to another person by seriously disfiguring a part of the body. In deciding whether or not an alleged perpetrator acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. For armed robbery, the state must prove that the alleged perpetrator took another person's property from the immediate presence of the other person by using an offensive weapon and with the intent to commit theft. An offensive weapon is an object that's either likely to cause or actually does cause death or serious bodily injury if it's used against someone. Conspiracy to commit murder. A person commits conspiracy to commit murder when that person conspires with one or more others to commit the crime of murder. Murder has been previously defined. Criminal attempt. A person commits criminal attempt to commit a crime when, with the intent to commit that crime, the person performs any act that constitutes a substantial step towards the commission of the crime. Criminal gang activity has been previously defined. Criminal use, a person of an article with an altered identification mark. A person commits the offense of criminal use of an article with an altered identification mark when he possesses a firearm from which he knows that the manufacturer's serial number or any other distinguishing number or identification mark has been removed for the purpose of concealing or destroying the identity of that article. Possession of a firearm by a convicted felon has been previously defined, but in addition, with regard to that offense, possession of MDMA with intent to distribute, possession of cocaine, and robbery are felonies. Possession of a firearm by a first offender probationer. For possession of a firearm by a first offender probationer, the state must prove that the alleged perpetrator possessed a firearm while on probation for a felony as a first offender. Robbery and criminal damage to property are felonies. Possession of a firearm during the commission of a felony has been previously defined, but in addition, for these overt acts, possession of codeine with intent to distribute and possession of cocaine are felonies. Possession of a machine gun. The state must prove that the alleged perpetrator possessed a machine gun during the commission of any of the following offenses: participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine. A machine gun means any weapon which shoots or is designed to shoot automatically more than 6 shots without manual reloading by a single function of the trigger. Possession of controlled substances. For possession of cocaine or oxycodone, the state must prove that the alleged perpetrator possessed any amount of cocaine or oxycodone, both of which are controlled substances. Possession with intent to distribute. For possession with intent to distribute codeine, hydrocodone, marijuana, MDMA, or methamphetamine, the state must prove that the alleged perpetrator possessed any amount of marijuana or any amount of codeine, hydrocodone, MDMA, or methamphetamine, which are controlled substances, with intent to distribute. And intent to distribute means intent to unlawfully deliver or sell. Sale of marijuana. For sale of marijuana, the state must prove that the alleged perpetrator sold any amount of marijuana, and sell here means to transfer marijuana in exchange for money or anything else of value. Possession of a weapon by an inmate. For possession of a weapon by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized weapon. For possession of a telecommunication device by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized cell phone. Conspiracy to possess a telecommunication device by an inmate. Commits conspiracy to possess an unauthorized telecommunication device by an inmate when that person conspires with one or more others to commit the crime of possession of a telecommunication device by an inmate. For terroristic threats, the state must prove that the alleged perpetrator threatened to commit a crime of violence and that the threat was made. Theft by receiving stolen property. A person commits theft by receiving stolen property when that person receives or keeps stolen property and the person knows or should have known was stolen, unless the property was kept or received with the intent to restore it to the owner. Knowledge on the part of the alleged perpetrator that the property was stolen, or evidence sufficient to show beyond a reasonable doubt that the alleged perpetrator had reason to know the property was stolen, is an essential element of this offense. Knowledge that the property was stolen may be shown by circumstances that would excite suspicion in the mind of an ordinary person. The burden is on the state to prove beyond a reasonable doubt that the alleged perpetrator had knowledge, or under all the circumstances should have had knowledge, that the property in question was stolen and was in the alleged perpetrator's possession. All right, that's it for the overt act crimes. All right, the law provides that criminal action shall be indicted and tried in the county in which the crime was committed. In a prosecution in any case in which it can't be determined that what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt it might have been committed. We don't have that here, do we? So essentially just the state must prove that the criminal actions alleged as counts in this case, that they have to be tried and indicted and tried in the county in which the crime was committed. So venue, that is that the crime was committed in a particular county, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of defense. Venue may be proven by direct or circumstantial evidence or both. To prove venue for the RICO count, the crime is considered to have been committed in any county in which an incident of racketeering occurred, or in which an interest or control of an enterprise or personal property was acquired or maintained. The defendants are each charged with certain offenses that are set forth in various counts of the indictment. Each count is a separate and distinct offense, and you must independently evaluate the evidence against each defendant and as to each offense. The fact that you reach a conclusion with respect to one offense or with respect to one defendant does not necessarily mean that the same conclusion will apply to any other charged offense or to another defendant. Each count of the indictment before you is separate and distinct. You must evaluate evidence as to one count independently from evidence of each other count. You must evaluate the evidence as to each defendant independently, and you must render a verdict as to each count and as to each defendant individually. If, after considering the testimony and the evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant in Fulton County, Georgia, committed an offense as alleged in the indictment, you would be authorized to find the defendant guilty of that offense. In that event, the form of your verdict for that offense would be to find the defendant guilty. If you do not believe the defendant is guilty of an offense as alleged in the indictment, or if you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense. In that event, the form of your verdict for that offense would be to find the defendant not guilty. You are to make a separate determination of guilty or not guilty as to each offense and as to each defendant. Your verdict as to each count must be unanimous. That means that you must be unanimous in your determination that the state has proven every element of that count as defined and listed above beyond a reasonable doubt. And you'll have a copy of these instructions out with you so that you can see what each of the elements of each of the offenses is. Again, the elements are listed above where the crimes are defined, and you must be unanimous that each element has been proven. Let me explain what that means for a few of the elements for count 1 a bit more specifically. And that's the conspiracy to violate the RICO Act. You must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. But because count 1 is charged as a conspiracy to violate the RICO Act, it's not required that the state prove that any conspirator actually committed an act of racketeering activity. And on the overt act element, you must be unanimous that a conspirator committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. And you would note on your verdict form that and any of other overt act committed in furtherance of the criminal conspiracy to which 12 of you unanimously agree. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of either defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against any party. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it's wrong. However, you should never give up an honest opinion simply to be congenial or to reach a verdict solely because of the opinion of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. And these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as the foreperson, dated and returned to be published in open court. During your deliberations, any communications from you to the court must be in writing, signed and dated by the foreperson, and given to a bailiff. And let me add that given that the evidence is closed, my ability to respond to questions may be limited. Evidence that was admitted by audio or video recording can only be played here in the courtroom. So any request to review or listen to that evidence again must be made in writing by you to the court, and then it'll be replayed in the courtroom. And that is the end of my instructions. I'm going to excuse you all to the jury room now to elect your foreperson. Don't begin deliberations until you have the indictment, the evidence, and the verdict forms and some copies of this charge out with you. And I'm going to ask jurors number 387, 409, 449, and 508 to hang back with me. And the rest of you can return to the jury room to elect your foreperson.
All rise for the jury.
All right, y'all are the alternates in the case. Considering the length of this trial, it was critical that we had alternate jurors in case we lost any jurors. And as I think y'all know, we in fact started with 2 more of you and lost 2 along the way. I don't know how long deliberations are going to take. And so it's possible that even now we may end up losing a juror or more. So y'all are still on jury duty. You're not going to be deliberating right now, but you continue to be under all of the instructions that have been applicable to you for the entirety of this trial. You cannot discuss this case with anyone. You cannot allow anybody to discuss the case with you. You cannot go now and look up any articles about this case or anybody involved in it. You can't look at any kind of social media or any other kind of accounts of this trial or anybody involved in the trial. Essentially, you're still on jury duty. I am going to, for the next hour or so, keep y'all around here. And Sergeant, maybe, I don't know, I'm sure there's probably another jury room that they can retire to. While y'all are on jury duty and the jury is deliberating, I want y'all to stay within an hour or so of this courthouse. If we're ever on a break, you know, we've got Thanksgiving break coming up. Obviously, y'all can go and do whatever your Thanksgiving break plans were because the jury's not going to be in session, court's not going to be in session, we're not going to be deliberating. But even when you're on those breaks and any others that might occur during the deliberation process, you still can't talk to anybody about the case or allow anybody else to talk to you about the case or look for any information in any way about the case. So essentially you remain on the same instructions. Just when we're on break, you're on break too. When the jury is deliberating, I need y'all to be where if we need you, we can get you within an hour, down here within an hour or so, okay? So for right now, you can go and grab your things. You can say goodbye, it's been great. I may see you again to your fellow jurors, and then we'll have you in one of the other rooms for a little while at least. And if I'm going to release y'all for the day, I'll let y'all know that. But again, just kind of stay within an hour or so of the courtroom. And just like you've sort of kept your cell phones in a way that we can communicate with you, continue to do that in case we need to. Thank you very much.
All rise for the jury.
Are there objections to the chart?
Just a few things that you mentioned around.
Okay.
On
On page 2? Okay.
When reading participation in criminal street gang activity for count 50, you said subsection 1 and not A. So I just wanted to
Hang
make
on a second. Let me get there. Page. Where are you talking about?
So count 50, where it's participating in criminal street gang,
Yes.
you said section 1 and not A.
Okay. Do you want me to call them all back in and say I meant to say A, or they'll have copies of this out there and it'll be on the verdict form correctly?
Yes, Your Honor.
All right.
That's fine. I didn't know if I had something different than what you had, and so I wanted to make sure that what I have in front of me was correct.
Okay.
Only as to page number 9, when you, last paragraph, any out-of-court statement,
Hang on. Yes.
as we were reading it, the thought came that maybe we should add any out-of-court statement made to law enforcement, made to the police, made by one of the defendants on trial in this case after the alleged criminal act.
We probably should have.
So just,
I gave y'all this, I don't know how many different times to look at and ask you. I don't know how many different times for any kind of comments or corrections. So what do you want me to do?
can we add it, then when you send it back?
Sure.
That's all, Your Honor. I'm just going back.
Made by one of the defendants, made to law enforcement by one of the defendants on trial.
Yes, Your Honor.
Okay, we can do that.
And as of right now, those are the only ones that I see.
All right, appreciate it. Thank you. Anybody else?
I have no objections to your reading of the jury charges, Your Honor. I just need to renew my request and objection to exclusion of jury charge 3.01.10, which is the justification, as I requested justification for my client's possession of firearm by a convicted felon. I requested that charge, so I'm just renewing my objection to the exclusion of that charge, as well as the separate and distinct charge that overt acts need to be proved. An overt act needs to be agreed upon unanimously by all the jurors. I know, Your Honor, stance that you referenced the need for unanimity, being unanimous. I always
Mhm.
struggle with that word.
Okay.
Within the jury charges, and I understand that, but I'm just going to renew my objection.
Okay.
Thank you.
All right. Then we will, y'all have agreed as to what evidence goes out?
Yes, Your Honor, there is we're including a flash drive with a list of the exhibits, the Stillwell exhibits.
Okay.
And I thought it would be appropriate, and if it's not appropriate, please object. It's just a list of the exhibit numbers. The flash drive is little, so you can't list them all. So we're printing on a piece of paper,
Okay.
and we're just going to attach the flash drive to the piece of paper.
Okay. And those don't go out. You're just saying you're listing them.
Understanding, well, you can't play them. My
Right.
understanding is that all the media was going to go in the back room. They can't play it, but then they could ask if they wanted us.
Just so they'll have a list of what it is.
I'm not even proposing a list of what it is and what each exhibit is, but just that these are the exhibits that are on this flash drive. I'm not suggesting.
We don't normally send the actual media out with them.
Okay,
I mean,
Yeah,
it's certainly in evidence and they certainly can consider it. This would need to say, hey, I'd like to watch the FedEx tape again.
Okay, and I had spoken to some members of the state about this. The understanding I had was that the movie was going to go out, but of course they have no way to play it, but then they could request.
Okay, are they gonna even, if it all, for instance, goes out in a bin, are they gonna even know what it is? Like, are they all labeled? Yes? I mean, it's fine with me if that's the way y'all want to do it.
The only other thing we were going to ask to do, I believe the defense counsel has an objection. We were going to send a legend out with the letters and what they what letter is associated with what act so that they would know.
What
We
letters?
organized
I
them.
don't know what you mean by that.
So every act that we presented, so for example, VV was the Shymel Drinks homicide, so that they could know when they pull up, when they pick up a
Hmm.
letter, what that was in reference to.
Hmm.
I'm gonna object to that, to the state's kind of direction of compartmentalizing the evidence, and quite honestly, some of the evidence that was admitted under certain letters applied to certain other cases. I mean, these aren't distinct. I know that they're charged as distinct over acts, but Walter Murphy testifies, for
Right.
instance, and he has things they admitted to Walter Murphy might have a WW, just for instance, but what he testified to involved different acts.
I mean, I think that as they were listening to the evidence, they could write down the number of the exhibit. So if they want to flip through their notes and say, you know what, I was really interested in 53 WW, then they can find that, or if it's media, they can ask to re-listen or replay it. I don't think that it's really appropriate to say, here's kind of the state schematic of the evidence. Okay. So have y'all otherwise agreed on what evidence goes out with them and what evidence doesn't?
So I've been presented some case law this morning, and we discussed it. I don't have any problem with the GBI reports going back. I know that was one bone of contention.
Mhm.
Don't have any problem with the ME reports going back. We've been going back and forth about two issues: the CAD reports and the
Okay.
demonstratives. I'm objecting to both the CAD reports and the demonstratives going back.
Okay. You wanna? Okay. All right. Does the state feel that the CAD reports or the demonstratives should go out?
Yes, Your Honor, we have case law regarding demonstrative evidence
Okay.
that demonstrative evidence does go back to the jury and it's not a violation of the continuing witness rule.
Would you like to share that with the court?
Yes, Your Honor.
Okay.
This state will cite Ruffin v. State, which is 333 Georgia Appeal 793, which is a 2015 case.
Mm-hmm. Okay. And then how about the CAD reports? Is the objection, what's the objection to the CAD reports? Okay. And does the state have a position on that?
Your Honor, the state does not believe that the CAD reports are a violation of the continuing witness rule, and we are looking, I thought we had the case on point, but we are looking for that case as well.
stands for basically what the continuing witness rule applies to, and cash report would not be something that is listed as something that would go back because it would be a continuing witness because it's an original evidentiary document and it's not testimonial in this nature.
Does it cover CAD reports at all, or is it just kind of, here's what continuing witness means?
It's just kind of what, here's what continuing witness means. I couldn't find a case specific or on point of the relationship.
It's hard to believe, honestly.
Which leads me to the conclusion they go back.
Yeah. So here's, does the defense have any case law on CAD reports? So I'm looking at a case, Muse, from the Supreme Court from last year, 316 Georgia, 639, and it also doesn't cover CAD reports specifically, but it's talking about surveillance videos. And it says, here the surveillance videos were not the reduction to writing of an oral statement, nor a written statement provided in lieu of testimony. And a CAD report, I mean, it contains the reduction to writing of an oral statement, doesn't it? So it may be that it can go out redacted. What does CAD stand for? Computer aided. Mm-hmm.
I wanted to share this in case it helps. My thinking is with us, the arguments we've had on CAD reports and 911 calls
Mm-hmm.
in our many days of going through upcoming exhibits, the court made determinations on testimonial versus non-testimonial with how we walk through and redacted. And so my understanding with the continuing witness rule is if a document is non-testimonial in nature, then it's not a reduction or substitute for the person's oral statement or testimony. In terms of that non-testimonial analysis is part of the genesis of the continuing witness rule. But, and that was why I wanted to share that. And this is coming from, I believe it's the same case that Mr. Abad cited, the PATTA. But that, I just wanted to share that because it just hit me that that pre-analysis, of course, with the CAD and 911 specifically, we have argued and the court has ruled on that part. That was all I wanted to share, Your Honor.
That's just about a case. It's pretty new. Date is the state, 71, Georgia Appeal 469, 2024 case.
I mean, in the Catarazi or whatever it is case, the continuing witness rule is inapplicable where the documented issue is original documentary evidence or where it's non-testimonial because it's not a reduction of or substitute for oral statements or testimony. It's certainly not a substitute for oral statements or testimony. And it is original documentary evidence. I think we already redacted out of every CADA report, at least since I've been involved, any hearsay, right?
Your Honor, it is true, what Mr. Atkins said, to my recollection, is completely accurate, as we did have a series, when we went through these CAD reports, a series of hearsay objections and confrontation clause objections.
Right.
Some were redacted.
Yeah. All right, so then I think it would be my conclusion that it is all right for them to go out as long as they're all redacted to cover the evidentiary rulings that I made previously, or that the predecessor court made previously. All right, did y'all, I hadn't had a chance to look at the demonstrative law yet. Yes. Right. My reading of Robbins is that demonstratives can go out with the jury. If y'all got something contrary to that.
We just be clear what demonstratives we're talking about. 'cause
Uh-huh.
they all-
Mhm.
I believe there's some physical evidence that Ms. Weaver may have in her,
She's got guns and drugs.
so the drugs.
Neither of those is going out to the jury.
Okay.
If you have pictures of them, those can go out. Or you suggest, is there anything besides guns and drugs she has?
We're gonna look at the
Okay.
evidence list.
Y'all aren't suggesting that either of those go out with the jury, are you?
No, we're talking, we have the jewelry upstairs. And, I
Okay.
mean, some of that may or may not.
Not sure we want that to go out with the jury either, considering the allegations in this case by one of the attorneys. So we've got an armed guard in there.
We're gonna go over the exhibit list, trying to see what else Ms. Weaver may have.
Y'all got pictures of the jewelry and pictures of the guns and the drugs, right?
Yes.
Okay. Those are in evidence?
Some of the picture of the jewelry.
Okay. Mhm. Sure, absolutely. Yep. There seems to be pretty
Excuse me, Your Honor.
yes.
Regarding Ruffin v. State, having looked at the demonstratives the state plan would like to send back to the jury, these are demonstratives that were, if not all, at least for the most part, I think all, produced by the state for use with their witnesses. Whereas
Okay.
in Ruffin, that was an anatomical chart apparently used. Well, actually, I can't tell if that was, it looks like it was used by a medical examiner in the parenthetical.
So I'm looking at, it's a fairly old case from the late 90s, but it says items of demonstrative evidence. It's Gabbard versus State. Hang on. Let me find that part.
Oh, Gabbard v. State,
Yeah.
Your Honor,
Mm-hmm.
233 Georgia App 122.
Yes.
Let me pull that up.
These were also anatomical drawings to illustrate victims' testimony.
There's a more recent case, Moore v. State, Georgia Supreme Court case 311, Georgia 506. It addresses demonstratives as well as the cell phone presentation and things of that nature going back.
So was that Moore v. State?
Yes.
Thank you.
311, Georgia 506.
Thank you, Mr. Abate. This case, Your Honor,
Mm-hmm.
I think it seems to imply that the lead detective is the one that prepared the PowerPoint summary that went out to the jury, not a demonstrative prepared by the state. Unless I'm reading it quickly, but it appears to be a distinction there.
Okay, so I'm looking at a case, McKenzie versus State, 300 Georgia App 469. It says the continuing witness rule does not apply to demonstrative evidence designed to illustrate testimony given by witnesses. Here, the documents complained of were designed by an investigator of, it was the DeKalb County DA's office, based on other admitted exhibits, including cell phone records, dates and times that checks were cashed. The documents were admitted at trial and served only to summarize the other admissible evidence. There was no violation of the continuing witness rule. That was more like a summary document, but I guess that was demonstrative and summary. And it was prepared not by the witness, but by one of the parties, and it was not subject continuing witness. Seems okay to me.
I'm going to have more of a challenge distinguishing that one, Your Honor.
All right.
Yeah, I don't know.
So I think unless y'all come up with something else, that I'm going to overrule the objection to both the CATA reports as described, redacted, and demonstratives going out. Other,
There are some pieces of physical evidence, Your Honor, hats,
okay,
other clothing items
yeah,
that we're having someone go to retrieve to bring them down.
okay.
And I think by the time we retrieve that, get everything, we'll be ready to
All right.
collect everything and have it sent back.
One other matter, there are two demonstratives that were admitted by Mr. Steele.
Okay.
Admitted at some point during the trial.
So I'm,
In January.
yeah,
I don't-
those are just blow-ups of
Yeah.
the language of certain
Yes, Your Honor.
overt acts.
They admitted when Trustee Stevens was on the stand. I don't particularly have a strong feeling one way or another about them going back. I'm not sure.
I'm thinking those aren't needed because they're going to have the indictment itself out, and that's really just a magnification of certain of those items on the indictment. So we won't send those out. And if y'all want to look through whatever other demonstratives there are, that might be a good idea. I feel like I asked y'all to do this several times, several weeks ago.
They just went through it, I
Hmm.
believe.
All right. Okay. Well, good. Thank you. So I keep. Can you do that? Yes. Hmm.
The state has demonstrated for the result of his writing during testimony.
Right.
I don't believe that those are covered under the case law that we're talking about. This is just literally writing in trial. I don't think that makes it demonstrative. Essentially, they were writing to encourage the jurors to write. Is kind of the way I saw it. Sending a message, writing something is important, but I don't believe it's appropriate for these to go back.
Thoughts? I mean, it didn't seem like that was being used to help the witness illustrate their testimony. It was more to help the jury kind of. Okay, so those will not go out.
Put these right here with them. Not those.
Okay. All right, let's take, y'all can continue to do this. Let's take a quick recess though. And I'll do that during the recess, and then maybe we'll come back and once it's settled, okay?
Honestly, this could be our recess /lunch if you want it to be. So if you want to come back at 1:30,
Y'all can just put a joint exhibit sticker on here or write joint exhibit 1 on here. That'll work for that. We've got copies of the redacted indictment to go out. We do not. We still have to sort out the language of those last couple of overt acts that we highlighted earlier. So can we figure that out? And do we otherwise have all of the evidence that's going to go out?
Your Honor, there was, a challenge during the lunch break to get into Judge Randall's chambers.
Uh-huh. Deputies can get into anybody's chambers.
They just got it maybe about 5 or 7 minutes ago.
Okay.
They're getting the evidence, the chain of custody form, and so they're trying to get chain of custody form.
Okay, well, I mean, it goes from one court reporter to another, so do you want the court reporter to just walk up there and take possession of the evidence? That's probably the best way to do it. Then we don't need a chain of custody form. It just is with the court reporter. Yes, we'll do that. All right, so we will recess for our delightful new court reporter to do that. Thank you, Ms. Taylor. Judge Glanville's chambers is going to, it's apparently a significant amount of evidence. They're going to basically wheel it down here to this courtroom, and Ms. Taylor, our current court reporter, is going to take possession of it. So that'll happen in the next 10 minutes or so. Can somebody, I guess I could do that, look in Odyssey and find out the date that's on the original re-indictment to put on this one? You know, when they signed, or who's got possession of the signed indictment? So that might still be, is it in here or is it still with, is it making its way downstairs? We need the date, so we need to see the. I would think that would be. Yeah, I would think the case manager would have it. Right. All right, have y'all looked at the highlighted language for the proposed ways to handle those couple of overt acts as an A and a B?
Yes, Your Honor, and the state had a proposal to, I think, simplify
Okay,
the matter in terms of starting with 183.
okay,
If the state just redacted possession of codeine with intent to distribute and possession of cocaine, because this is the street gang charge, so the jury will still be tasked with the other revisions of did Arnold or Williams possess those items individually. So for purposes of 183, the state proposal is to redact to where it only remains possession of marijuana with intent to distribute and possession of firearm during commission, which tracks the language.
okay. So leave all three of them and have those two kind of offenses only.
Yes, Your Honor.
Okay,
And for 187, the state's proposal is the same, to remove possession of codeine with intent to distribute and possession of cocaine.
okay.
Can I ask a question? So would that mean that we would end up with what?
What is essentially 187A
183A?
and 183A,
Okay,
right?
thank you. That's what it seems to me, and I just want to make sure my
But those
understanding is
wouldn't
correct.
say A anymore. They would
Right.
just say 183 and 187.
Yes, Your Honor.
Okay, yeah, that works if that's,
And the state, and I can email this, but with our previous discussion on the 133 charges and the language, the state, if you stop, like, for example, take 189 or 190,
okay,
if you stop after an associate did commit the felony offense of possession of firearm by convicted felon, and then redline everything up to where you start by possessing a Glock, and then we would obviously remove for 189 specifically, we would remove the machine gun,
right. Okay,
and then just pick back up, possession of a firearm in indictment, and then cite the felony and the date, and keep it overt action furtherance.
that works as long as, so the question on the floor for that had been, can an overt act be modified to drop it down to a lesser, essentially? Do we have an answer to that?
Your Honor, I'm going to let Mr. Floyd
Okay,
address that with the court because we do have a,
give me just a sec.
yes, Your Honor. Yeah. Yes. I wasn't here that day. Maybe I was here.
All right, thank you for your patience.
Of course, John. So the approach we took in this, to try to avoid any problems was only to remove language, not to add anything.
Mhm.
Nothing's been added.
Right,
I want to be clear, it is not exactly the same situation, but the most analogous thing I can find in the time available is an 11th Circuit RICO case, United States v. Watchmaker, spelled exactly as it sounds, 761 F. 2nd, 1459 at 1468. It's a 1985 case.
okay.
In that case, in that situation, analogous to this, the court found there were certain predicate acts for which no evidence had been presented. It removed them from consideration, from the indictment that the jury saw.
Right,
That was held not to be a problem.
okay.
And so here we're removing actually less, we're actually removing a subset of that, as it references the specific individual defendant in whichever circumstance we're talking about. The others are not at trial, they would have no ground to complain.
Right.
They're not parties.
All right,
So I think it's on all threes at least. But I can't really find a problem with it because we've restricted in this circumstance solely to deletion, not
Okay.
addition.
It would seem that, I mean, of course, I haven't had a chance to read this Watchmaker case yet, but if they're removing an entire predicate act, that would seem to be more analogous to removing the entire overt act rather than amending the overt act. But again, I haven't read Watchmaker. I'm just wondering if amending the overt act, we would be running into a constructive amendment claim, constructive amendment of the indictment.
Well,
Because-
two aspects. I didn't mean to cut you off.
No, please go ahead.
Okay. Two considerations on that, Your Honor.
mm-hmm,
One is the meaning of the word amendment in this circumstance. So if we were changing it to refer to another offense or adding words, that would constitute an amendment. This, to the extent it's an amendment, is exclusively an amendment by deletion. And it is tailored to those aspects where Your Honor found there was an absence of evidence. There's no prejudice to the defendant. It's favorable to the defendant. I'm not aware of anything that says you have to cut beyond the scope of where you found there was a shortage of a failure of evidence. I don't think there's anything that compels that conclusion. In other words, I don't think this is a throw out baby with bathwater scenario.
I would argue that the amendment is actually not favorable to us. That amendment by deletion actually broadens out that overt act. It does not work in our favor because you're removing the
I agree, it
elements.
doesn't work in the defense's favor to make it easier for the state to prove an overt act.
Yeah, and that thus it's conduct beyond that which would appear in the original grand jury indictment, and that would amount to constructive amendment.
Yeah. You know, I mean, even I'm reading Watchmaker right now, and part of it says the court did not change the terms of the crime with which Keating was charged, which I'm not changing the crime, but I'm changing the crime in the overt act. I think the safer thing to do is just to redact the indictment to remove those overt acts. I'm not convinced that it might not be error to do the way you propose. I think logically speaking, it sounds like it should make sense, but in the absence of something that makes it clear to me that it's not error, I would hate to borrow a term from one of y'all, get to, you know, the 90, y'all haven't said it, but almost, I don't know, it was some, never mind. It was some kind of football field reference that I'm not going to be able to do right. So just never mind. The 1 yard line. And then, yes, y'all probably
I
said
thought
2
you were going
yard
to say
line.
risk introducing further error into this case.
No, I don't know that there is error in this case at all. I don't know.
Okay.
There is typically, you know, there are no perfect trials. We know that. It will be up to potentially some other court to determine that issue down the line. But right here today, I would hate to be on the now 1 yard line and do something that does cause an error that couldn't be corrected.
And so, Your Honor, if I can respond to that, two points. One, it's important, I think, to be specific as to which acts we're talking about.
Okay.
So with 183, there's no change in the nature of the crime. We're only talking about striking out those specific instances.
Right.
I can't imagine any problem from that.
Yeah, no, I agree. I was talking more about the possession of a firearm by the whatever they were, 174, 175, 189, and 190. I'm just going to redact out completely. With regard to 183 and 187, I think those are fine to have just gotten rid of the things that I directed a verdict in Mr. Kendrick's favor on.
Thank you, Your Honor.
And Your Honor, with regard to, I had 2 points.
Okay.
One is, when you're talking about, forgive me if I get the number exactly wrong, but 170, I think it's 174, 175, 89, and 90.
Yes.
And so with those, the specter that's been raised is, to paraphrase the defense, the appearance of error where none currently exists, as we are at first in inches. However, because of the way you have instructed the jury to handle the overt acts, if they find these, and if there's a defect, those in public court simply strike them from consideration.
Unless they're the only acts they find.
In which case we would know that as well.
All right.
Because they're going to number it.
Understood. I'm just going to redact them. Y'all will still have over 100 overt acts for them to evaluate. All right, so I am redacting out to delete 174, 175, 189, and 190. Don't know why it won't let me. And then on 183, it will be the language that is now 183A, but it won't say A, it'll just say 183. And then the same with 187. Yes.
This argument may be fixed, but with both of those, of course, redlining or removing the possession of codeine, the intent to distribute and possession of cocaine from the bottom.
Right.
The last version I saw on 183 and 187 still had those included.
Oh, it doesn't anymore.
I think the state may be looking at the B language and not the A language.
That's perfect, Your Honor.
All right. All right, I think I can't do the rest of it until Ms. Percival comes back because she has the same document up and for some reason it's not letting me remove the highlights. All right, I see that our mainly physical evidence has arrived from Judge Glanville's court reporter's office. And Ms. Taylor, our current court reporter, will take possession of it. And do you all know what's going out and what's not? Because the jury has had this case for an hour and a half now, but they haven't been able to deliberate because they're awaiting the evidence. And that is why I told y'all for the last several weeks to make a determination about what evidence was going to go out so that when they got the case, they could get the evidence too and begin deliberating. So I'm kind of ready for that to happen.
Like 173, which will be on page 41. Right, yeah. So that's going to go 176. Clean up the formatting. Yes. Well, I showed it to them and then they wrote one, I wrote one.
All right, Ms. Percifield has what we think is the final redacted indictment. So with the changes we just discussed, so if everybody can take a look at those, they start on about page, 40 or so. Just take a look at those, confirm that they are what everyone has agreed we're going to do. And then if so, we'll print it out and that'll be ready to go to the jury as well. At which time, the last thing we will be waiting on is the evidence.
Yes.
Yes, ma'am.
How far are we time-wise from getting this to the jury? Perfect. All right, while y'all are doing that, I'm just going to put on the record that with regard to the guns and any other physical evidence that's not going to go out with the jury, for instance, the drugs, the DA is the official custodian of that evidence. And so the DA will remain in possession of that evidence, and y'all need to keep that in your locked evidence room. The court reporter is not going to be taking custody of that, the guns and that other type physical evidence that is not going out with the jury.
I know, right? I'm only doing 12 things.
Can some member from each team be dealing with the rest of what's just paper evidence and making sure that everybody is on board and on the same page with regard to that?
We've done that.
All right.
We just need to make sure we send them. I think we know we separate things. We just gotta make
Okay, I am ready to hand all of this to the jury in the next 5 minutes. So whatever needs to get done, let's do it now.
Yeah, those.
Yeah, right here. You can put, I think that's extra. That's just extra stuff. Yeah. Working on the. Is that the BD charges? They're just extra. You guys want, I don't know what they belong to.
This is stuff that's not going back.
That's extra, I don't know who they belong to, it's just extra. I think it's just folders. Yeah.
Well, and this is stuff that's not going back.
There's literally, it's just folders that is what's in that box. I don't know who they belong to, they should just take them wherever they belong, so trash. I don't know if I've caught it. Yeah, it's too confusing.
I don't know, we do have pictures of the gun.
Uh-huh.
But in case the juror, for whatever reason, they want to see a certain gun.
Then y'all will have to wheel it over and we'll display it in the courtroom.
So we can't keep it over here while they're delivering.
No. Mm-mm. No, I mean, they might deliberate for a month and a half. We might need to use, I'm going to be using this courtroom for the other defendants in this, on this indictment. So no.
Your Honor, Ms. Birchfield, these are, I separated these. This is investigator Dennis's stuff that was taken out. This is
Okay.
the Jimmy Winfrey, plea that was taken out,
Okay.
and, a transcript for, Mr. Sledge.
All right.
So these are all different things that were either removed from evidence, never in evidence.
Can you make sure that 444Y and 1AS are not going back? They were, I think maybe Ryan, I don't know, something to do with, no, I don't know what they were. I just have a note to myself that those are continuing witness.
Your Honor,
Mhm.
I've looked at the revised indictment that we just received, and it's acceptable to me.
Thank you.
Guys, do you know what wire?
Why should we afford it?
That may have been Mr. Sledge's pleas or something like that.
Works. See it, it's right there. You cover here, sir.
What was that number again on one? 444. I think it's the Weinstein has it. You looking for staple? Yeah. I mean, I have a small one. That's real tiny. It's not like this. Like traveling.
No.
Okay. Okay.
All right, and I'm just going to put on, Ms. Taylor, I'm going to put on the record that I realize if you put on the record for me, put on the record for me.
Okay.
Give me a second.
Okay.
All right, so 1AS that I referenced before, I've realized that is the exhibit number from Mr. Sledge's plea, and it's not the exhibit number for this trial. The exhibit number for this trial is 444Y. They were just the same thing. Yeah.
But the 444Y would stay in there.
It's in evidence, but I don't think it would go out.
So that came in because that was back and forth about.
They're the same. No, that was it. It was 1AS, but that's not an exhibit to this trial. So it was just the way that exhibit was referenced in Sledge's agreement. So don't worry about that at all. Okay. Yeah. Okay.
You got that phone, you ready? Yeah.
All right. I mean, if we're ready to start wheeling it in, we don't have to have all 5 things at once. We can wheel in number 1, carry in number 2. I am.
He wants the verdict form.
They're all right there in the middle, right there. Yeah.
Here they go. That's all of them right there. That's everything. Oh, is that in here? Wait, the indictment is not there. The indictment is not there. The indictment.
With the printed out.
Yeah. Yeah.
All those demonstratives that are right there go? Okay, thank you.
And Your Honor, this is just for purposes of the record.
Okay.
The state has reviewed the revised indictment and it's going to be printed. I was just going to put for the record that the state would object to the removal of the 133 counts, overt acts, that are 174, 75, 189, and 190. Thank you, Your Honor.
Is that ready right there, guys?
That's not on. Yes.
None of that's on? What is it?
She's waiting for the.
No, it's in evidence. What else?
I don't know. These ask them.
These are ready, right?
These right here?
Yes.
This,
You can use the lid, just don't give me that paper.
all this is ready?
That's the cover.
No lid?
No lid? Oh, okay. What happened? They're over there. They're over there. LT.
Look, there's so much more room.
No, I have a few things, but we're waiting.
I just figured I'd kept all that together. I'm gonna try it like stuff. Oh, good. Thank you, just in case we need it. Yeah, or wheel it back there. I don't know where you want it. I guess put it, you can pick it into the jury room in case they want to use it.
Yeah, I'll let you know.
Right, the jury is deliberating. Ms. Horsfield's going to check to make sure she has a cell phone number for each of the attorneys, because obviously we have no idea when and or if they might want to ask a question or look at evidence. And so we all need to be on standby. We're all still in trial. And I need for people to be able to get here, in 5 minutes time. Ideally. If you have a special place you need to be, we can talk, but in short order. And obviously the defendants will continue to come over each day that the jury is deliberating, so that they can also be available to come to the courtroom if need be.
I apologize if the court has already stated this. When will the jury end their deliberations today, and what is the schedule for them
Oh,
tomorrow?
it's in what time?
Yeah.
Well, I have instructed them through the deputies that they need to stay at least until 5. If they want to stay beyond that, they're free to. Not past 7 ever. Which I don't think they're going to want to anyway.
Oh, yeah, they're going back there. Before they Oh.
All of this is like, all of this down.
Yeah, I was like, I don't know what's going on.
All right, and so they would like to continue to come in and start at 9, which is fine with me. So I'm going to say, just like a regular day, 9 to 5 with a lunch break. There will be days that the court provides lunch for them, and on those days they can choose to deliberate during their working lunch if they want to, or they can not deliberate and just take a break and eat. I'll make it clear that they can only deliberate when all 12 of them are there together. With regard to tomorrow, since it is the day before Thanksgiving, I'm going to say that they can leave at 3. And other than that, if there is some day or time that we need to alter that schedule, we'll just take it up as it comes.
And if they, I don't mean to ask for such detail, but if they decide to stay past 5, will we be notified of that so that we know to stay around the courthouse after 5? Or if they decide to stay after 3 tomorrow, will we be notified of that? I just want to make sure I don't leave the courthouse if they decide to deliberate late.
Sure.
If I have cell phone numbers for everybody, I'll do a fun group text chain and then text everybody what the schedule, what's going on, very briefly.
Thank you.
Friday.
Hmm?
Friday, regular court date?
No, Friday was already scheduled as a holiday date a long, long time ago. No.
May I approach?
Mm-hmm.
On the record, off the record.
I'm gonna make sure we do this first and then I will. Yeah,
Oh my
exactly.
God,
Oh,
that's
for sure.
hilarious.
Absolutely. We're only using WhatsApp, come on.
That's a good one. That was a good one. Yeah, she's getting it. Yeah.
It's, yeah, my printer decided to be crazy.
It has a mind of its own.
Apparently, yes.
No more boxes, just paperwork.
Correct.
Okay.
Yes.
Always put numbers. I know. Give me some numbers. You gotta send some. Okay, let me see how they go.
It doesn't look like it, I swear.
Oh, no, I get it. It's your system, so it doesn't have to look good to me. Oh, somehow, this is wrong. Oh, Fulton County Paige. Awesome. I know, right? Sorry. Is it? Okay. Okay, thank you. We didn't say anything, but glad you told me. We didn't say anything.
All right, with that, That is everything. The jury has the case. And we are in recess until such time as we hear from the jury.
So 2:32.